So Mike Amesbury is out of prison, but not out of the woods. Not yet. He might still lose his seat in Parliament, for reasons I'll explain in this video. But there's also been quite a lot of outrage on social media in response to this sentence and his appeal to the Crown Court against his sentence, because if you haven't heard, his sentence has now been suspended. So it's still a 10-week custodial sentence, suspended for 2 years. And so the effect of that is that he doesn't go to prison, unless, of course, he breaks the terms, doesn't comply with the requirements, or he commits any further offence and then is recalled to prison on this and any further offence that he may commit. And so, as I say, there's been quite a bit of outrage on this because quite clearly we shouldn't really be condoning and allowing this sort of behaviour without due punishment. And that is the real key here. But there is a bit of a problem here, and it's not really with what the judge has done, and I'll explain why in this video. And also, before you leave this video, I'm also going to link my learned friend Alan Robertshaw's video in the description below. He's got some thoughts on this as well. Do go and watch that. Do subscribe to his channel as well. But this has attracted quite a bit of commentary. And let's go to what Robert Jenrick said. There's a couple of things here, one of which I'm going to very subtly disagree with, but and I'm not quick to disagree or criticise, but I will tell you why. But the first bit is actually quite clear. He says, this week's sentence gives a green light to thuggery and violence. Deterrence matters. And I agree that it's a weak sentence. It's not necessarily wrong for the offence that was charged, but that's important for reasons I'll come back to in a minute. But it is a weak sentence for what he did, and I wouldn't go as far as to saying it gives a green light to thuggery and violence. But what it does do is mean that if people commit this sort of act, they should be able to expect that sort of a sentence where they don't actually go to prison. They just get a suspended sentence as long as they've got a clean history and all the factors are the same that the court considers, etc. But some people may then feel that that's what they'll get if they commit that sort of offence, and I think that's wrong. I don't think that is enough of a deterrent, but that's just my personal view. But when we look at what actually happened, and I'll take the CPS's summary of what happened because obviously it was prosecuted, and so this is how they describe what happened. Alison Story here, Senior Specialist Prosecutor, says, this was a persistent assault by Mike Amesbury, which continued while the victim was on the floor, offering no aggression. And I've always said in my videos, if someone's on the floor and you continue to punch them, then that is quite clearly an increase in aggression by the offender. The victim was alone and not part of a group, and CCTV showed that he was not being threatening or aggressive toward Mike Amesbury. After the initial punch, which knocked the victim to the ground, Mike Amesbury struck the victim at least a further 5 times whilst he was on the floor. The CPS will always seek to prosecute violent offences in accordance with our legal test, regardless of who the perpetrator is. But I do have one criticism here, and I'm not quick to criticise, but I do have a criticism here. And the judge picked up on this as well. And that I can phrase as a question. Why was this only charged as a single charge of common assault? When for many reasons, I mean, it didn't go as far as, breaking bones and things like that, but it could have been charged as a fray. My learned friend Alan Robertshaw goes into a good description on a fray, but essentially it involves 2 people and a third. So one person directing the violence, another person against whom that violence is directed, and a third person of reasonable firmness that it may cause them to fear immediate harm. And so the judge questioned this in going through this case today. The judge questioned why this was not charged as a fray, and obviously then it may have been sentenced differently. But the judge quite rightly said that he was not going to go behind the original charge and thus look at the case as it would have been looked at the magistrate court by the district judge there and sentence it accordingly. And the sentence the judge reached was the same in terms of the 10-week sentence, but then went on to suspend it because of mitigating factors. Now, this is still a custodial sentence. Now, that's a bit of an oxymoron in that it doesn't go to prison, but it's still a custodial sentence because it is a sentence of 10 weeks custody, albeit suspended for 2 years. And all that means is he doesn't go to prison, and so long as he behaves for the next 2 years and complies with the requirements, then he doesn't go to prison. But that's not the end of the matter either, because there is also other requirements, we go back to the CPS page. I'll come back to Robert Jenrick's post in a minute. Going back to the CPS page, he was also ordered to complete 200 hours of unpaid work, community service, undertake a 12-month alcohol monitoring requirement, which I'll come back to in a second, complete an anger management course, and carry out 20 days of rehabilitation. The alcohol bit was interesting. Going back to the Chester Standard that reported on this today, the judge raised the point that the probation service were disappointed that he only reduced his alcohol intake instead of removing it out of his life. Now, just as an aside here, anyone who's ever in trouble with anything that's remotely related to alcohol would be best advised to abstain from alcohol completely and demonstrate that you've given it up completely, to demonstrate that you've seen the error of your ways. Also, I've heard many barristers advise that when someone is involved in anything to do with road traffic matters that has let's say a fast car or sports car or something like that, that they either garage the car or they sell the car to demonstrate that they've seen the error of their ways in the way that they've been driving, and they're taking steps to improve that. And I've heard that reported to be very successful in court, because it's a very powerful statement to say, well, I realise and recognise that using that car in that way is dangerous. Therefore, if I get rid of the car, it's demonstrative that I'm taking steps to improve things. So in this case, the judge raised the point that probation was disappointed that he'd only reduced his alcohol intake instead of removing it from his life completely. The judge then raised anger management issues, etc. And so the judge then ordered that he's got a monitoring requirement for alcohol for 12 months, but a 12-month alcohol abstinence order and anger management course. But coming back to the second point by Robert Jenrick here, he says it risks the perception of two-tier justice. A court hearing Amesbury's appeal within 72 hours when more serious cases are being listed for 2028. Absolutely, it does. It does risk the appearance of two-tier justice, and the disparity between the two is massive. But obviously, those are two very different cases, different types of offences, and there are only really two fairly small but good reasons why this was heard so quickly. One is that because it was a 10-week custodial sentence, obviously if it took longer than that to appeal the sentence, then there's no point appealing the sentence, so it would be heard relatively quickly anyway. And secondly, because it's an appeal from the Magistrates Court to the Crown Court, that has to be done within 15 business days. I understand that was indicated immediately because he applied for bail and bail was refused. That is another reason that it was heard so quickly. But that's not to say that I agree that that's right. And that's not to say that I agree that it should be like that. It should not have been, because he's an MP. In fact, the judge was quite clear today to say that he's sentencing him as a member of the public rather than as an MP. And that works both ways, rather than punishing him more because he's an MP, and rather than giving him any leniency because he's an MP, whichever way you think that should lean. The judge was clear to say that he would sentence him as a member of the public. But the bigger problem here, aside from how quickly this appeal was heard, which many people will disagree with, and I'm not saying it's right that it was heard so quickly. In fact, with the backlog in the system, I think there are lots of other cases that were probably pushed aside to get this in. I can only think that logically there were lots of other cases that would otherwise have been lined up to go to court to be heard today that weren't, because of this one, but I'm not involved in that, so I can't really comment. But as to the charge itself, it does leave a bit of a question mark as to why this was only prosecuted as a common assault, because if we look at what actually happened again, it's relatively serious. Now, thinking that a single punch, I can't use too many descriptive words and language on YouTube, otherwise the video gets flagged and banned, but a single punch can do extensive damage, if you know what I mean. And so this was not just one either. This was one that knocked him to the ground, and then the video showed, according to the CPS, at least a further 5 while he was on the floor, which I think should go. I mean, I'm not a specialist. I've done criminal work, but I'm not a specialist criminal barrister. But I, both as a barrister that has done some criminal work, you understand, and as a member of the public, with the knowledge that I have as a barrister, if that makes sense, I think this should have been charged more seriously. I mean, I would invite my colleagues to comments, they probably won't, as to whether this should have been charged more seriously than just a common assault. But here we are. This is how it was charged. The district judge in the magistrates court gave a 10-week prison sentence, and it's been modified here subtly to have it suspended and these additional requirements. And so actually looking at this in the round, you might think that the 200 hours of unpaid work, the 12-month alcohol abstinence monitoring requirement, and an anger management course and 20 days of rehab, is this rehabilitative justice at work? This could be something that actually puts somebody on the right track who is otherwise angry out in the street and punching people, and it might actually work. And this might be something that we should be looking to as a society. Again, let me know your thoughts to that in the comments below. Or should it be straightforward and just send into prison to send a deterrent message out that if you do this, you go to prison? Let me know what you think in the comments below. But why is he not out of the woods yet? Because it is still a custodial sentence, even though it's been suspended, which means the recall petition is still triggered, and it's only 10% of the constituents to vote to have him lose his seat. So again, a recall petition is triggered if an MP is convicted of an offence in the UK and receives a custodial sentence, including a suspended sentence, or is ordered to be detained other than solely for mental health, suspended from the Commons for 10 days or 14 calendar days, convicted of providing false information, misleading information, etc. So the recall petition is still triggered, and it only takes 10% of the constituency to sign the petition, and then they lose their seat. And then who can sign the petition? Anyone that's registered at an address to vote. Signing the petition. To sign the petition, you need to go to the allotted signing place. A petition officer will send the details of the location and opening hours, etc. So you can look for that if you're in that constituency. So there's a broad outline of what happened today. Don't forget to check out Al Robert Shaw's video, link below, more discussion on Affray and this case in general, which I hope you find interesting. I'll link that below. But let me know what you think. This one really is splitting the hairs. And for what it's worth, I think that this is not enough of a deterrent. I think he's got off lightly. I wouldn't go as far as saying this is a green light to thuggery and violence, but what I think it does do is it does send the message that those that have a clean record that do this kind of thing should expect not to go to prison, albeit they get a criminal record and a suspended sentence, etc., if everything goes down exactly the way it did today for them. And of course, I don't recommend that. I don't condone that. I don't think that's right. And nobody should do that, just to make all of that absolutely clear. But I do think this is not enough of a deterrent. I have to say what I think. Just what I think. Let me know what you think. And as always, thank you for watching.